Hey guys, what is up? It's Dusty here, and welcome back to another crypto video. Today, we have some breaking news on the Ripple v SEC lawsuit. Breaking! SEC just filed a motion to quash deposition of William H. Hinman, ex-SEC director of the Division of Corporation Finance. And guys, oh guys, is this some interesting news? I'll explain to you guys exactly what this means and exactly why this is so interesting throughout this episode. But if you enjoy these swift updates, make sure you press that like button. I, unfortunately, didn't read through 82 pages if you were thinking that of me. It has only been like an hour since this news came out, and, well, it's already been a complete... I don't want to call the word out, but what a shit show. Oh my days, have people gone berserk over this news? Let me tell you guys exactly why. So, SEC has just filed something, right? A motion to quash. What is a motion to quash? Well, in easy terms, it's just a motion to kind of get something out of the way, right? To just, let's say, just destroy. In the easiest fashion, quash most likely has some really posh meaning that I do not know, but this is as far as I've read from Google now, all right? I've been doing my research a little bit. Now, to quash a deposition of an individual, well, let's take a little bit of a look. A motion to quash is a request to a court or other tribunal to render a previous decision or proceeding null or invalid. The exact usage of motion to squash depends on the rules of the particular court or tribunal. In some cases, motions to quash are requests to fully nullify a decision made by the same or lower court. Extremely important, that last part. Now, a little bit down below, you can also see most motions to quash a subpoena involve timelines, relevancy, improper court, undue burden, the time spent covered, standing, and invasion of attorney-client privilege. Another one that's extremely important and relevant. Why? Well, okay, let's dive a little bit back into what's been going on, right? Former SEC director who led Ripple action lands new role at Ethereum firm. Who are we talking about here? We are talking about this specific guy here, William Hinman. Let's dive a little bit deeper because you might not understand just quite yet. William Hinman is in a lot of these articles named, and this specifically here is a 2018 little call from William Hinman on the official SEC website, basically talking about digital assets, specifically Ethereum, in our opinion, what he kind of discussed, and Bitcoin and ICOs, and just the fact that they were, what their status were regarding to Howie, and how the SEC later on said that whatever he said, William Hinman, a member of the SEC, didn't matter. It's been a full discussion for so long. On the Crypto Law website, you can actually find here a tag for William Hinman, because we on the channel here, but also everybody over in the XRP community, specifically John Deedon, digital asset investor, Jeremy Hogan, James Fillon, a lot of other guys have posted or reposted a lot of these connections between William Hinman, Jay Clayton, and Ethereum/Bitcoin. And basically, it is said that those guys had some bias in getting Bitcoin and Ether the proper status. If you read some of the reports, which you can do for yourself, what you're noticing is that, well, even though they don't necessarily say something too crazy, they are kind of contradictory. And what that comes down to is whenever you talk about Ethereum, you can never say that it doesn't fall into the category of an ICO. And any paper that you read from the SEC side, once it talks about ICOs, which most of them do, you'll notice, well, following your own logic, Ethereum should be a security at one point or another too. Even Gary Gensler, who is now the head of the SEC, has at some point or another admitted that Ethereum should be a security if we were to just look at the first couple of years, right? If we were to take away the current use case and the current structure, basically, again, being in Zurich and whatnot, it should be a security to some degree. It just depends on how you kind of put that timeline together for yourself and how you want to stretch it, but the conclusion still remains the same. Now, Digital Asset Investor specifically is every single day posting more and more connections between Jay Clayton and just the bias, basically, because we wanted to see why exactly they went after XRP, but not after Ether. Like, what exact opinion? But that's all aside. We wanted to know, that's most important, why whatever these guys said right here, for example, an entire freaking book he wrote, it kind of looks like, on digital asset transactions, or digital assets in specific. Why that's not relevant? Because, again, kind of look back. Ripple states one thing, and that is that whatever the SEC said here should be considered market information. And what I mean with that is that it should be that whatever they quote on digital currencies, that you as a normal investor should be able to take that advice or take that information and kind of perceive it as the truth and the current way the regulations are. This is an official SEC speech we're talking about, yet the SEC likes to argue that whatever they put in such a speech doesn't necessarily matter. Why it's important is because if it turns out to be that all the things they say is relevant, then again, we can take those points that they mentioned about Ethereum, about ICOs and whatnot, and compare it to XRP, for example. But right now we can't. That's why Ripple is trying to look inside of the US SEC and basically get some information about some of the SEC members, what their stances were on crypto and what their connections were to other crypto projects, maybe if they traded crypto, all that type of stuff they want to have, they want to see. Because Ripple would like to point out that if the SEC ever had an opinion on XRP but they didn't let go of it, that's something strange. If they never had an opinion on XRP, then how could Ripple have known, right? That's, again, the fair notice defense that it kind of comes down to. And basically the lawsuit against the Chris Larsen and Brad Garlinghouse, basically the individual defendants, because it's also being said that they were disregarding the law. Now, whenever I think about it, I come to the same conclusion. They should investigate the SEC for what they knew. They should give these documents regarding Bitcoin and Ether and XRP. They should give everything over to kind of cooperate and come to a good conclusion and further on a good lawsuit. Because if you think about it, if we as normal investors cannot really find out why exactly Bitcoin and Ether are not securities, but then from a certain perspective, XRP kind of is, how am I supposed to know how to classify all these cryptos now? I'm a crypto investor. How am I supposed to see which ones are good and which ones aren't if the SEC isn't necessarily guiding us? It's strange, right? So Ripple's been trying to dig. And now again, the SEC has come in with a freaking hammer to try get Ripple down. Because the SEC does not want Ripple to investigate them. Have you guys understood that? The SEC is denied on multiple different occasions to give over information regarding the status of Bitcoin, Ether, and XRP. It's been ordered by the court twice, and now Ripple has kind of been putting some pressure on that. It's perceived now that Ripple has got some info in the background, but we haven't heard about it. But damn, oh damn, am I getting annoyed by this entire situation. It's kind of strange how it's getting to my head, but yes, I'm getting annoyed by this entire situation. It's just mind-boggling to me how stupid and slow this is all going. Now, yesterday we were kind of covering, it's 2 days ago already. It is now the 25th, so it's officially 2 days ago, but kind of yesterday, we were already covering this part here. The defendant's request for the SEC's internal trading policies is granted. The court finds that the information sought meets the low bar for relevance, including potentially with respect to the claims against the individual defendants. And also, the SEC announces intentions to file on Thursday, June 24th, a letter motion to quash a deposition subpoena served by Ripple on a former SEC official, briefing scheduled below. So we now have it confirmed that it is not Jay Clayton. It is, at least as far as I know now, it is William Hinman that Ripple was trying to get some information for, to put him on a stance, and the SEC is now, breaking news, trying to quash it, or basically trying to get that down. On what basis, you might ask? Well, you can read 82 pages if you want, or however many pages it is, but you'll see they're nice and labeled. Director Hinman held a position of critical importance to the SEC's operations. Director Hinman has no first-hand knowledge of the facts underlying this action. The subpoena should be quashed because defendants cannot meet their burden of demonstrating exceptional circumstances justifying it. Director Hinman served as a high-ranking government official, so he's kind of, higher than most things. You know what this one means. It's not that difficult. Defendants cannot demonstrate exceptional circumstances to actually get this info from such a high-ranking individual. Defendants cannot properly elicit testimony on the SEC's internal processes and can explore the SEC's assertions of privilege through less instructive means. It just goes on a little bit. Director Hinman has no unique first-hand knowledge of market participants' understanding as to the regulatory status of XRP offers and sales. This part they actually, I think, kind of are trying to cover up because obviously the request is for XRP, Bitcoin, and Ether, not only XRP, in whatever request they have. So that he has no first-hand knowledge of that regarding XRP. It doesn't really matter. And most likely the SEC knows that too. They're just going to make it a point to make it look good for the SEC, for the judge. And that's actually the first 9 pages, by the way. The majority of what you need to know about these exhibits are basically just proof and extra relevant information. But the first 9 pages here specifically are what's most important. And I've noticed now that many people get kind of scared when you see a paper that's 80 pages long and whatnot. But guys, most of the time, if you just kind of scroll through, you'll notice, hey, okay, it's just 4 pages with 75 pages of exhibits. Oh, it's just 1 page. Oh, it's just 3 pages with a lot of exhibits after it. So that's just a little fun fact. For these reasons, defendants cannot meet their burden of establishing that exceptional circumstances justify Director Hinman's deposition. Accordingly, the court should quash the subpoena. In an alternative, the court should quash the subpoena without prejudice until after Judge Torres' ruling on the SEC's motion to strike Ripple's fairness defense. If the court grants the SEC's motion, Ripple's principal basis for seeking to depose Director Hinman would no longer exist. So what that kind of is supposed to say is Ripple likes to or wants to question Director Hinman mostly because they think that they were not given fair notice and that they couldn't have known, basically, because either the SEC didn't know themselves or either the SEC did know but they didn't tell them or something along those lines, and that's what they're trying to figure out. Now, the SEC is now arguing that if the SEC successfully strikes Ripple's fair notice defense, they have no more reason to investigate, basically, Director Hinman, which is interesting. If the court does not, its interpretation of the defenses may nevertheless determine whether Director Hinman has any first-hand knowledge of facts sufficient to meet the exceptional circumstances test. And I would like to say, yeah, he has a lot of first-hand knowledge of facts because he was there when the decisions on Bitcoin and Ether were made, and those are extremely relevant to determine what the stance should be on XRP, right? So from my perspective, he is always going to be relevant, and having him on a pedestal, it's going to be an amazing decision. So I actually didn't see here that there's another update 8 hours ago. Attorney Daphne Waxman just filed a formal appearance for the SEC, probably just filed now because of an oversight, as she previously signed other pleadings and declarations to the case. So I believe she just officially entered into the lawsuit, but she has already been in that for a little while. Okay. Because she already put her name on multiple different things before. All right, so that was a little update for right now. Interesting, yet also not that interesting. I personally am so extremely excited about everything that's going on still, guys. I still just think the SEC is trying to hide some stuff, and I can't keep titling my videos that way, so I'm not exactly sure what I'm going to put here. It's been a really bumpy ride. It's been so freaking stupid what the SEC has been trying to achieve, but in the end, I'm just letting it slide. I'm just letting it slide over me, I guess, and just seeing as we see more updates. In the end, I just want to see what their stance was in XRP, Bitcoin. I just want to see the quote-unquote corruption that people talk about too. I just want to see Jay Clayton and William Hinman put on a pedestal and, put up to talk. But the SEC is trying to, not allow it. So let us see what the judge decides, or let us see how Ripple responds to all of this. I'm pretty excited to see this continue on forward, and I'm pretty sure Ripple will win. But in the end, I'm not a lawyer, not a financial advisor, so my opinion doesn't really mean that much, but all right. Make sure you subscribe for more lawsuit updates, and let me know if you like the opinion next to it, or would you just like the facts as I can find them. Just let me know in the comment section too.